Just recently, I was contacted by a family member. Their loved one had just been arrested on being involved in a major narcotics conspiracy by the federal authorities, and they wanted to know what was the course of action, what should they be doing. I suggested that the first thing you do is, firstly, you have to get a copy of the charging instrument, and after you get an opportunity to review the charging instrument, the attorney who you would be consulting with will make your loved one aware of the charges, make you aware of the charges, and in a major narcotics conspiracy, you have to really address the bail issue outset. When you're charged with a federal offense, narcotic federal offense, there's a presumption against bail. So you have to really see how do you get around that presumption. And the family and the attorney then must go about the task of trying to find a way to convince the judge that there are facts and circumstances that would sufficiently satisfy the court's concern about someone's ability to return to court and answer the charges, as well as any danger that they might present to society. So from that standpoint, we want to make sure that the family member, as well as the accused, understands the charge, and then we go about the task of trying to put together a bail package that would effectively get that person home. Sometimes we have to be very creative. Sometimes we come up with a package wherein their liberty would be somewhat constricted, meaning that he or she might be on electronic monitoring, GPS, or home detention. The notion, however, is that you want to get out on bail. You can defend yourself far more effectively if you're out on bail, because you give the attorneys, you can certainly assist in your defense and give the attorney that aid and assistance that he should be looking for. Now, after you get through the bail standpoint, you want to consider, well, what's the nature of the evidence against me? You want to find out whether or not there are wiretaps, whether there's a cooperator. You want to find out just the nature of the evidence and the quantity of the evidence that's there. And from there, you make a determination as to whether or not this case is one that must be tried, or this case is one where you go about trying to get the best disposition that you possibly can. And winning in federal court doesn't necessarily always mean getting an acquittal. More often than not, when you're charged with a federal offense, you're going to be charged with what's called a mandatory minimum offense, wherein that mandatory minimum is 10 years in jail. You want to try to eradicate that mandatory minimum, or at least bring that mandatory minimum from the 10 to a mandatory minimum of 5. But the better course of action, however, is to try to get a non-mandatory minimum offense so that you can be far more creative when time comes for sentencing to try to get your client out and back to his family as quickly as possible.